Welcome everyone, I am Raquel de Haro from the ETH Center for Law and Economics, and I am happy to introduce Professor Nick Feamster from the University of Chicago. Professor Feamster is the director at the Network Operations and Internet Security Lab at the University of Chicago, the founder and co-director of the Internet Equity Initiative, and the director of research at the Data Science Institute. In his research, he uses empirical network measurement and machine learning to understand and improve network performance, security, and privacy. Today, we will talk about his paper Measuring Compliance with the California Consumer Privacy Act over Space and Time, and Dark Patterns in the Opt-out Process and Compliance with the California Consumer Privacy Act. Welcome, Nick.
Thank you for having me, Raquel.
Before we dive into the discussion, don't you explain us a bit what's the summary of the papers and what were the motivations behind each of them?
Great. So as an internet measurement researcher, I've long been interested in various aspects of privacy on the internet. For many years, for example, we looked at connected smart devices in homes and how the behavior of those devices interacted with various privacy regulations in the United States and elsewhere. And from 2020 forward, as we saw states in the United States start to enact specific privacy laws, I was very interested to measure the effects of those laws on internet websites, and in particular how those websites were implementing or not the provisions of these privacy laws. So our collaborators at the University of Chicago Law School and also the Washington University and St. Louis Law School actually suggested that we look at how these websites were complying over time, because at the time that we started the study, many states started to implement these laws, and we could see then as these laws were being enacted in different states how websites may have been responding. Also, I think another aspect that I owe my law school collaborators the inspiration for was this notion of spillover. So the idea that a law that is specific to California might have effects on internet users who are not California residents, who are not in the state. And so we were able to measure those effects, those so-called spillover effects.
And what would you say is the main contribution of each of these papers?
That's a good question. So I think there's a couple of ways to view the contributions. One is, I think we'll talk about it a little bit more, is the methods themselves, because one of the things we were interested in figuring out is could we do automated compliance checking. Like, in other words, could we automatically check whether these websites were complying with the provisions of the privacy laws? And so some of the contributions are methodological, looking at basically how do you automatically check for compliance, or can you automatically check for compliance? And then I think another set of findings or contributions is really what we found from the measurements themselves. In particular, the fact that many sites were not compliant with the privacy laws. We saw that. We also saw, I just talked about the spillover effects. We actually saw that many of the websites that did implement the provisions of the privacy statutes actually implemented them outside of the states where those laws were enacted. So yeah, the method contributions, and then the findings such as those that I mentioned, as well as I should mention also the data sets themselves are available for others to look at.
So in both of your papers, you mentioned the challenges of monitoring compliance, and I was also interested in knowing what are these challenges and what is particularly interesting about monitoring the CCPA.
Yeah, that's a great question. And in fact, I found actually the challenges that we faced, they came as a bit of a surprise to me as well. So to talk about the CCPA compliance and the subsequent CPRA compliance, one of the provisions in that statute is that websites had to implement an opt-out link. Or let's start with the CCPA, right? Had to implement an opt-out link with very specific wording. And I thought actually it'd be fairly simple to go visit these websites. We call it scraping sometimes. Scrape these websites and look for that very specific language. Now, as it turns out, even doing something as simple as figuring out whether that text is present on the web page in the form of an opt-out link turned out to be rather difficult. Sometimes we could find that text in the source code of the web page, but it wasn't visible on the page itself. Sometimes it was visible on the page, but not in the source code. So we had to look at the page in many different ways, and then also sometimes validate our methods with manual inspection to make sure that we were actually testing compliance correctly. So that was just the CCPA, where there was like one set of there's one phrase for an opt-out that had to be present. The CPRA then introduced multiple alternatives that websites could implement, alternate forms of the wording, even an alternate form of the wording with an icon present, so it had to have both. And then also they allowed for websites to implement the so-called global privacy controls, or these frictionless opt-out mechanisms. And so suddenly we had to check for the presence of any one of these mechanisms. So anyone who's maybe tried browser automation for testing or web scraping knows that actually this can be quite difficult, and even just testing for some of the presence of some of these simple features turns out to be quite difficult. In the follow-up paper that you mentioned at the outset, we also started to look at whether the opt-outs were implemented with so-called dark patterns, or in other words, ways that would make it difficult for the user to implement the opt-out. So in other words, introducing a lot of steps to cause the user to opt out, or making it difficult for them to find the link, or doing things with colors or fonts or placement on the website, or number of clicks that would make it difficult to opt out. And as you can imagine, there are many ways that kind of obstruction or misdirection or interference could be implemented. And if we're testing for that in an automated way, the same kind of things that make it difficult for a user can actually make it difficult for automated testing. And so there's a lot of sort of manual inspection, corner cases, verification that's needed in all of these cases.
And what do you think that the policymakers and regulators should take into account when drafting legislation like the CCPA to avoid having enforcement issues afterwards?
That's great question. I think we could take some lessons, I think, from other areas where policymakers have been looking at enforcement on the internet. So one such area is in the area of broadband internet access, where recently there's been regulation that would require internet service providers in the United States to provide machine-readable so-called broadband labels. In other words, information about the connectivity that the internet service provider is selling to a consumer in a way that a machine or a program could read and process, and then check that against automated performance tests, for example. So we don't have such a thing for the CCPA, the CPRA, or any privacy statute for that matter. But one thing that we do see is that many websites use common libraries to implement these opt-out mechanisms. So provider like OneTrust or some other service provider might implement these types of opt-out mechanisms on behalf of the website. And so I would say that perhaps regulators and those implementing the opt-out mechanisms on behalf of these sites could work together to make automated compliance checking easier. You know, that machine-readable label being a type of analogy that we could learn from in this area as well.
Interesting. And you mentioned the spillovers effect of the CCPA, and now I want to ask you, do you think that the CCPA is a de facto national privacy law in the United States?
I think California, when they make laws such as this, they're trying to be de facto. I think we did see a significant amount of spillover, and I think in the paper that you referenced, and I think it was something like, of the sites that implemented the opt-out link correctly in a compliant fashion, something like 3/4 of those websites implemented it across all the states that we looked at, even in states where there was no privacy statute. And so whether or not it's de facto, I think that's pretty strong generalization, but I think it's definitely safe to say that we are seeing, like, when one state implements or enacts a particular privacy statute, we do see these spillover effects, or websites implementing those provisions across the country. And we didn't look globally, but I think an interesting follow-up would be to see what this looks like globally as well.
Thank you, Professor Feamster, for sharing your interesting research with us today.
Thanks for having me for this discussion. It was a pleasure to visit you.
And for our viewers, we hope you enjoyed this episode as much as we did, and see you next time.